Good afternoon. This is Sean Golding with Golding and Golding, here to discuss a little bit about what some of the common defenses are to a late filed Form 3520 penalty assessment. Over the past 6 months to a year or so, our team's been updating all of our articles and our posts, and we get a lot of inquiries about Form 3520. A lot of the information out there is horrible. So it's important that taxpayers have an idea of what they can do and what they can't do, and how they can possibly avoid or abate a Form 3520 penalty. Who may have to file the Form 3520? Typically, it's 3 categories of individuals: U.S. citizens, lawful permanent residents, foreign nationals who meet the substantial presence test. Typically, those are going to be visa holders, whether you're here on like a B1, B2 tourist visa, EB5 investment visa, L1 work transfer, H1B employment visa, any of these. Even if you're not on visa, but typically it's when you're on visa and you remain in the United States for a significant amount of time sufficient to meet the substantial presence test, then the IRS lumps you together with U.S. citizens and lawful permanent residents. You have a worldwide income requirement as well as international information reporting. Form 3520 is used for lots of different reasons. Primarily, though, it is used for large gifts or inheritances. Joe or Jane receives a $700,000 gift from a foreign non-resident alien parent, let's say. The taxpayer doesn't know they're supposed to report it. They find out later down the line that they were supposed to report it, and then they file the late form. Unfortunately, international information reporting forms, when they're filed late and they get penalized, they're what's called automatically assessed. It doesn't go through deficiency procedures. You don't get a pre-notice or a warning. You just get a CP15 notice that shows up at your doorstep. It's certified typically, and we'll say, hey, 25% penalty. If it's more, it's 5. Typically what it is, it's 5% per month up to 25%, but most people don't realize they were supposed to file it till several months after the due date, and thus typically it's going to be a 25% penalty. So what can taxpayers do in order to try to defend against penalties? So there's a few things taxpayers have to consider, right? One is, have they been penalized yet, or are they making a proactive submission? In other words, are they going to try to avoid any penalty being issued by doing a delinquency procedures, a streamlined procedures, or a reasonable cause submission? Or have they already been penalized and now they're on the defensive and they want to try to abate those penalties? So when it comes to reasonable cause, right, reasonable cause can happen either before the penalty is issued as a proactive kind of reasonable cause submission. There's no particular form. It's an alternative typically to the streamlined domestic, or ancillary to a delinquency procedures submission. Or sometimes it can be after, in which the taxpayer receives the CP15 notice and then they protest and possibly appeal collection due process. Different types of options that they can choose, but it's either pre or post, right? So some reasonable cause ways to do it is a mistake. And what can happen is if the taxpayer used due diligence to try to figure out what they were supposed to do, but they didn't get the right answer, but they tried, then the IRS may waive the penalty. For example, a taxpayer may think, oh, my preliminary research made it seem like it's the person who's giving the gift, which is true if you're a U.S. person. Or, I went into TurboTax, I did my FBAR, I did my 8938, but it doesn't ask anything about 3520, and the form's not even available on there. I didn't learn about it till later. And so I did some due diligence, but I just didn't get to the end result I was supposed to. IRS may be able to waive the penalty there. Tax professional reliance. This is a situation where maybe a taxpayer went to a CPA or an attorney and said, hey, I got this gift from my foreign parents. They're non-resident aliens, and the tax preparer CPA attorney goes, oh, you know what? They're not a U.S. person. They're not subject to any tax. There's nothing you have to do. And the question then becomes, is that person that the taxpayer relied on someone who actually has some sort of expertise or experience or not? These days, anyone can go online and say they're board certified when they're not, the self-proclaimed experts. They got a few years of experience. The ABA wrote a great article about this a few years back about attorneys with like 10 to 15 years experience who suddenly like to plaster the internet claiming that they're experts. But if the attorney is taking the position that they know international tax and so you can rely on that, then that can be sufficient in order to make a professional reliance defense in terms of reasonable cause. And then ignorance of the law, that's a harder one, but sometimes if the taxpayer, depending on the education level, they like to say, or maybe they only became a U.S. person for tax purposes, this year, and this was the first year they were required to file, and the first year they were supposed to do 3520. It all boils down to like a totality of the circumstance, right? You look at the facts and circumstances, and the IRS agent examiner looks and goes, hey, maybe I think based on these facts for this taxpayer, I think the penalty should be waived or avoided. Excuse me. Something else to keep in mind, sometimes someone will come to us and go, hey, I got hit with this big penalty, and it turns out that actually what happened is they didn't even need the 3520 because it was a gift that was, it was for medical payments paid directly to the hospital, let's say, or educational purposes, but paid directly to the education, to the university or whatnot. So that, it's important to kind of look at those facts too to make sure the 3520 is even required to be filed. If the taxpayer doesn't want to do reasonable cause, they may be able to do the streamlined procedures if they meet the requirements, and there's various requirements. Typically, if the only issue is a 3520 and there's no FBAR and there's no FACA, so there's no penalty, since for streamlined procedures it has to be based, it's a Title 26 miscellaneous offshore penalty based on the unreported accounts, assets, and investments, doesn't include gifts. We've had situations where taxpayers come to us and the IRS says no dice. If the only thing you have is 3520, you should have done delinquency procedures. And so that takes us to delinquency procedures, which used to be a great program. There's something called delinquent FBAR, and there's something called the Delinquent International Information Return Submission Procedures. The latter category is for people who have multiple forms that may be due or forms beyond the FBAR, and they used to grant a penalty waiver, which was great, until I believe it was November 2020 when the IRS said, you know what, we're not going to do this anymore. There's no automatic penalty waiver. We have a ton of free information available on our main websites and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.